Welcome to this free immigration help channel. Today is June 2nd, 2023, and we're getting into the volume 106 of me answering your immigration related questions. As you can see, I have all your comments pulled up in front of me. As always, before beginning, I'm going to mention I am not an immigration attorney. This is not a legal advice. All the information provided in these videos on this channel are directly from official government sources like USCIS, and of course the Department of State with their visa bulletin. So let's start with the very first question from Seth Odum. Sorry if I'm mispronouncing the name. My petitioner, my daughter, has misplaced her marriage certificate. Would this affect my chances at the visa interview? Seth, thank you very much for the question. That's a great question. I don't think it's gonna cause any problems because if it was requested, and because I petitioned for my parents myself, and during the NVC, well, my status was single, so I didn't have to provide the marriage certificate. I'm assuming as a married petitioner, she did have to provide the marriage certificate during the process of becoming documentarily qualified with the NVC. So if it was uploaded, then most likely it will be required for the interview. If not, then probably not, because what they request for the interview are the same documents for the most part that you need in order to become documentarily qualified. So my recommendation is, if you have the chance, if you have the ability to reach out to the government organization that issued the marriage certificate, depending on where she got married, whether here in the United States, in whatever state, right, or outside of the United States, if there is still time, if she can reach out and try to get the replacement marriage certificate, that would be much better, just to be on the safe side, because if whenever it comes to my recommendations, it's always try to do everything as safely as possible. If of course you don't have the chance in order to get that, just get a copy of, because most likely you should have the copy of the old marriage certificate that she had, and have it in a separate folder. Just in case if they ask it during the interview, at least you have the ability to show the copy and say, yeah, well, I have the copy, I don't have the original of the marriage certificate, which they're not gonna ask for the original regardless, so the copy might be good in case if they ask for it, but still, to be on the safe side, try to get it replaced. Alrighty, so let me put this, and we're gonna move on to the next question from MC. How long does it currently take to get an approval for Form I-129? Where can we get this processing times information? Thanks, MC. Thank you very much for your question. Let's take a look. For that, we're going to go to the USCIS.gov, which is the official government website for U.S. Citizenship and Immigration Services. You can find the link for this website in the description of this video. This is what the front page looks like. We're going to click on Tools right here at the top of the navigation menu. And then we're going to go to Case Status Online. And there are a few different ways that you can find this page, but this is how I do it. So here, obviously, you can check the case status. You can check, by the receipt number and see what is going on the case. But if you scroll all the way down, you will see USCIS processing times information. Visit page, we're going to click on that. And you will have this page in front of you. So we're going to click on this right here. I-129. And then the category, depending on which category. Let's say, for example, if you're in the E category, E-treaty traders, select that. The service center, there's only one for this particular category, California Service Center, but depending on your category, you might have a few different service center options. You can find which service center your application is being processed at on the notice of receipt that you receive from USCIS. And get processing time, and there you go. So 5.5 months for this particular one in this particular service center. Keep in mind, 80% of the cases, so 20% of the cases still take longer, and some of them take faster than this. But this is a very good rough estimate. So what I'm gonna do is I'm gonna post this right here, and I'll put this link so you don't have to search for it, or you can just click on this and find your category, find your service center. I'll copy this back and move on to the next one from Denise to Ford. Denise, thank you for another question. Appreciate it. Hi, sir. Becoming documentary qualified for F1. How long does that take if priority date is March 2017? Thank you. Alrighty, let's take a look at the visa bulletin. So first we want to find out when the NVC opens up the full access to the portal. And if you're not familiar with the process, check out the video that I have just uploaded today, where I explain basically the estimation process from the very beginning with USCIS, the whole thing, just the complete family reunification process, and then the stages: USCIS, NVC opening the portal, waiting for the backlog for the immigrant visa to become available, for the priority date to become current. So check it out. But let's take a look at the visa bulletin. So we know F1. We're going to look at the right here graph B, because we are looking at specifically the opening of the portal to become documentarily qualified. And this is what the graph B is showing us. It's showing us the priority dates that are becoming current as of right now, as of this month, June 2023, getting the full access to the NVC portal. So right now we see January 2017, and Dennis here is March 2017. So Dennis, you are roughly 2-3 months away from getting the full access to the NVC portal. You already have the access to the NVC portal. You already have the case number and the invoice number. But in a couple of months, you will be getting the NVC, the letter from the NVC, welcome letter from the NVC, saying that the portal is now open and you can start your process of becoming documentarily qualified. And Dennis, if you haven't seen the video that I've made on becoming documentarily qualified and what that process entails, I highly recommend you checking it out, because 2-3 months, you're going to be dealing with all of this. So the more prepared you are, once your portal opens up, you can, 2-3 days, if you have everything ready, all the documents, submit everything, pay all the fees, done, right? And then wait for, for them to documentarily qualify you, and then wait for the availability of the immigrant visa. All right, but great question, Dennis. As always, thank you very much. I'm gonna post this, and we're gonna move on to the next comment from Bruzy. Bruzy B, yes, I'm already documentary qualified, and I'm writing from Liberia. Thanks so much for your response, Bruzy. Anytime, appreciate your comments. The 60 days notice sent by NVC ends 15 of this month's June. It's my hope I get my welcome letter. I've also been writing the US Embassy here in Liberia back and forth, and they keep telling me NVC haven't sent my case file to them yet. Aha. When they receive my case, they will contact me. While at the same time, NVC is telling me they're waiting for the embassy in Liberia to let them know when the interview will be available before contacting me. Been a bit confused about that. Yeah, Bruzy, sorry you're dealing with this. This is how these guys work, all right? This is what they do. That's why I say most of the times don't be upset if you are, if you're sending some kind of letter to the any of these government agencies, and you receive an absolutely boilerplate copy-paste response. That makes absolutely no sense. Most of the times they're just trying to shift the responsibility and say, oh, hey, it's not me, it's those guys, and then you contact those guys, and they're like, oh, whoa, it's not me, it's those guys right there. It's horrible. But on the plus side, you have all of this evidence of this communication back and forth. So in case if it really starts to get out of control and starts to get, where you are waiting for too long, and it's now becoming, something is wrong, something is unfair, and you really start to, try to find different avenues for help, whether you're hiring an attorney, whether you're reaching out to elected officials here in the United States, senators, governors, and asking them for help to interfere in your case and help you dealing with this. And you usually, when it's time to do that. You know when it's time to do that because when you contacted everybody and it's now, past 3 months, 4 months, 6 months above what typically it should be, then, it's time to take some kind of action. Then it's time to reach out. And in those situations, this communication is very, very helpful because you can send it to whoever you're reaching out for help, whether it's an attorney, whether it is an elected official, and say, look, I tried to resolve it all on my own. Here's all the communication. Here is me reaching out to NVC. Here's me reaching out to US Embassy. Here are their responses. And look how ridiculous they are. And that right there is, really everything that's needed for whoever is, trying to help you with your case, to look at it and say, okay, yes, so this person tried to resolve it on their own, but they couldn't, so I have to interfere and help them out. So that's why I always say, if you do reach and the case is outside of normal processing times, if you're looking at the visa bulletin and you see that the availability of your immigrant visa should have been 2 months, 3 months ago, the interview should have been scheduled like 3 months, 6 months ago, and you're still not scheduled and nothing is being resolved, you might want to start looking at these avenues. But before you start looking at these avenues, you need this evidence showing that you tried to resolve it directly on your own. Always, of course, maintain your professional attitude, being polite, so far so forth, because you don't want to start any unnecessary drama with these guys, because it's not good, definitely not good, because I've seen some cases where it didn't end very well when, you don't want to start drama with these guys for sure. But at the same time, you don't want to let the case go and just whatever happens, happens, because bad stuff happens when you do that. Okay, let's move on to the next one from Dawa Sherpa. There is 2 tables, A and B. How to know which one for me? I am in F2B category and my priority date is March 2018 and already got NVC case number and invoice ID through email. Dawa, congratulations on getting approved with USCIS and getting to the next stage. Excellent question. So, at the Visa Bulletin website, right? If you want to see the full length of the backlog that you will be dealing with from the very beginning of the day you submit the I-130, the date is accepted by USCIS, and the actual availability of the immigrant visa, then you are looking at the graph A, final action dates. That's for people that have been already documentarily qualified. They have been already, obviously approved by USCIS, by NVC, documentarily qualified, and they're waiting for their availability of the immigrant visa. That's it. They're just dealing with a backlog. So from very beginning to the very end, from start to finish. So F2B total right now, if we're looking at all chargeability area, it's showing September 2015. So you are in March 2018. So you are roughly about 3 years, 3.5 years. My math is horrible. So roughly 3 years away from the availability of the immigrant visa. That is, if you don't have any delays in becoming documentarily qualified, so far so forth. But there is another graph, that is graph B, that you're referring in your comment, and that graph is helpful for you to know when the NVC portal will become fully available to you so that you can become documentarily qualified. Because right now, I'm pretty sure, sometimes NVC makes exceptions and they open up, the full access to the portal a little bit earlier, but I'm pretty sure right now, you do have case number, you do have the invoice ID. If you log into the portal, you can log in. But there is nothing that you can do in the portal because it is still closed. So if we look at the graph B right here below, dates for filing, at the F2B category, we will see that it shows January 2017. And you are March 2018. So you are roughly about, January 2017, March 2018. So 1 year and 2 months. So now you can estimate that roughly in 1 year and 2 months, you will have the full access to the NVC portal where you can start your process of becoming documentarily qualified. And again, I would highly recommend checking out the video that I've made. It is on this channel, it's uploaded on this channel. It's called Documentarily Qualified. What does that mean? And in that video, I show the actual NVC portal of the person who was already documentarily qualified. And there you can see which fees you will have to pay, the visa application, the affidavit of support, which documentation that you would need to provide. So if you prepare all of this, you still have 1 year and 2 months roughly, another year before you need to be dealing with this. So no rush. But if you're prepared, once that NVC portal fully opens up, you have everything ready. You pay all the fees quickly. You submit all the documents quickly within few days. And then, next few months become documentary qualified, and then you're just waiting for the availability of the immigrant visa. And then again, once you're documentarily qualified, and now you're just waiting for the availability of the immigrant visa, you go to the graph A to see the full length of how long you'll have to wait. So roughly another year for the NVC portal to fully open up, and then roughly, let's see, September 2015, and you are March 2018, roughly 3 years for the availability of the immigrant visa. Alrighty, let me put this here in the response, and we're gonna move on to the next question or comment from Adus Abu Bakr. Mumita Rahman, my love, I love you. He will. I guess Adus is telling somebody. I don't know who. Maybe me. If it was really helpful, I appreciate it. If that's me, if it's somebody else, well, it is what it is. Moving further, Vanilla Sagram. Hello, sir. How do inquiry, please? Okay. So if you want to do inquiry, because you commented on the video that I, immigration news, so it's really hard. So if you're doing inquiry with NVC, right, with the Department of State, then this link right here, the visa bulletin link, and you can find this link also in the description of this video. From this link right here, from this page, you will see at the very top, contact us. So click on this. I'm going to open it in new tab. And that is if you want to reach out to the NVC, to the Department of State, regarding the immigration visa, regarding the family reunification petition. US visa contact, click on that. Scroll down a little bit and you will see at the very first column or row, actually very first row of this table, public inquiry form right here. So we're going to click on the public inquiry form, and then you'll scroll down a little bit more and you will see online immigrant visa inquiries, only public inquiry form. So we're going to click on this as well, and that will give you the public inquiry form that you can fill out online and send it and inquire about the case. You'll have to put the case number here, the beneficiary's full name, beneficiary's date of birth, petitioner's full name, select who you are, whether you're a petitioner or beneficiary, your email address, and then your inquiry. Again, I'm going to mention, please always be polite and professional in your inquiries. Now, that is with the Department of State, that is with NVC. Now, in order to contact USCIS now, if your case is still with USCIS, the best way to do it is through the same thing. When you go to the case status online through tools, like I showed earlier in this video, scroll down, you will see there is another tab right here called Submit a Case Inquiry. And what I'm going to do actually, you know what? I'm going to do this. So here, whatever the reason is for your inquiry, you can select it here. Let's say cases outside normal processing times, and the same thing, you'll have a form where you will put the receipt number, you will select what kind of form it is, and you will have the opportunity to mention, the inquiry regarding your case. So 2 ways to do that depending on where your case is at. But I'm gonna put link for USCIS right here, just so that you don't have to look for it. I'm gonna go back to this page and I'll post this one, and then obviously the public inquiry form for the NVC. You've seen it earlier. The links are in the description below. Alrighty, moving further to the next question from Baha Rockstar. I think I'm pronouncing that correctly. Thanks for the information. My grandma was American citizen. She do the petition in 2003 for my dad and family. In F3 family sponsor, I guess need 6 years more in Mexico category. Bahar sir, I'm sorry, your dad has to be dealing for so long with this. It's ridiculous, honestly. For Mexico, unfortunately, this is the chargeability area that takes forever. It takes the longest. So let's take a look at the F3. F3, we're gonna go to the graph A and F3 right here. And yes, Mexico, as you can see, wow. November 97. So your grandma submitted the petition in 2003. So yes, you're accurate. You definitely understand the estimation with the visa bulletin. I really hope it doesn't slow down in any way, and it really is 6 years. In fact, hopefully it speeds up. We will see. There has been some talk, some conversation within the Department of State that they have came up with some kind of new streamlined process using the technology and getting rid of a lot of administrative work. Hopefully that is the case, and hopefully it speeds up. But yes, roughly another 6 years. Crazy. Since 1997, people who filed in 1997 are just now in 2023 are getting their immigrant visas if you're from Mexico. That's ridiculous. That is ridiculous. That's people who are doing it legally. Their relatives came here legally. They are legally here. They're petitioning for their relatives to do everything legally to come to the United States. And they have to wait for 26 years. Crazy. Okay, moving further to the next question coming from Tang. Hi, good evening. Thanks a lot for your help and selfless share. Anytime. I have been watching your videos for a few days. You have helped me a lot. Thanks again. Can you make a video on how to apply online for asylum application form? In addition, I have a question. Although I have watched your video on how to write a statement, I am still a bit confused. I have written 10 pages. Will it be too much? And some evidence is gone. How do I explain it? In addition, is it okay to only have a copy of the evidence? Because I was afraid of customs inquiries when I entered the United States, I didn't carry it. Tang, excellent inquiry. Thank you very much. I appreciate your comment. So the reason why I cannot do the online application for the for the asylum is because there is really no way for me to kind of start a test application. In order to start an online application, you do have to really register for USCIS account. And when you start the application, you start the real application, you can put the fake information in there because then that application sits in the real USCIS online account. Unfortunately, there is no like fake creating some account with a fake name and stuff like this because it's, that would not be such a great idea. But the video that I've made with the paper application, it's pretty much exactly the same question. So if you follow the video that I've made on regular paper application, the most updated one on I-589, it's going to be exactly the same thing, pretty much for the most part, that you will be dealing with in the online application. Because it's exactly the same questions, it's exactly the same instructions for both. Now, moving further to your next question regarding the 10 pages. It's definitely not too much. It's anywhere between 3 to 5 pages is considered normal standard. But obviously for everyone it's going to be different because everybody's stories, the experience they've been through is going to be different. So depending on the situation of a person, if you need to put more information in there, if it's 10 pages, 15 pages, hey, this is your experience, this is your story, and this is what you're claiming the asylum based on. So absolutely, if it's 10 pages, then it is 10 pages. Now regarding the evidence, if some of the evidence is gone and you are unable to provide it, just do your best in explaining why that evidence is gone. Just like you explained to me in the comment, that is a very, very valid explanation, and it absolutely makes sense. If you're running away from the country where you are being persecuted, obviously you are not going to be carrying in your backpack all of this documentation, all of this stuff that, if you're stopped during the customs search, they see a whole bunch of documents on you and they look through it and they might get a picture and they might not let you out of the country. So that definitely makes sense. So the same way you explain this in the comment, the same way explain this in your statement, and you will be doing the same explaining in the interview. Keep in mind that there's always the external evidence that you can find that is not specific. Let me rephrase that. Not that it is not specific to you. It will be specific to you, but it is not specific to your case. It is specific to similar cases of other people that are in a certain group that is being persecuted in the country. Let's say, for example, and I'm giving a rough example, you are claiming asylum based on religious beliefs. Let's say you belong to a certain religious group, right, that is being persecuted in the country that you're running away from. You came here to the United States and now you're applying for asylum based on this religious views, persecution based on religious views, right? Let's say you don't have the evidence specifically to your persecution. However, most of the times you can search, and it's a simple online search, using search engine like, for example, Google, finding reports from organizations, international organizations like UN, for example, they have their different kind of reports. I think Red Cross, they might have had something similar. World Health Organization, UNICEF, they have similar reports that they do on the countries. In those reports, because they do kind of like they have their people in the field, their workers that collect all of that data, all of that information. In those reports, a lot of times you can find the corroborating evidence to your case, saying that yes, this particular group, this particular religious group is being persecuted, whether by another religious group or by the government. So even if you have from your personal experience evidence missing, you might be able to find that larger on the macro scale evidence that in that particular country, people in your religious group, and again, it's all like this example, but are being persecuted. And that is definitely a strong evidence, because it is, organizations that are recognized, and the information that they provide is definitely recognized. So search around, maybe you will be able to find something like that. Of course, if you don't have the originals, copies obviously will definitely do as well. If you don't have the copies that have been notarized, that's fine. A lot of times, again, you cannot do that. But the same stuff that you explained in your comment, just make sure you explain it in your written statement, and it's definitely going to be fine. Just do your best with the evidence. Just do your best explaining everything in the statement, and it should be good in a lot of ways. Again, a lot will depend on how the interview goes, but again, the same thing. Just be prepared for these questions during the interview. Kind of like, hey, why don't you have the original? Or why couldn't you bring the original? As long as you're prepared to answer these questions, you will do just fine. Alrighty, let's move on to the next question from Flor Canales. Sorry if I'm mispronouncing the name. I am watching your videos. It helps me a lot to choose an immigration lawyer, but there is a paralegal who is willing to help on filing the papers. Is the paralegal can represent his client in court? I'm waiting for the answer. Thank you. Flor, thank you very much. That's a great question. So no, paralegal cannot represent the client in a court. Well, let me correct that. Literally anybody can represent anybody in the court. All right, you can just say, oh, okay, this person is going to be my representative in the court, and that's really it. Now, are they as qualified as an immigration attorney to represent you in the court? Not really. Okay, you probably don't want to be dealing with that. Can they help you fill out the documents? Yes, absolutely. Especially if they're experienced paralegal, if they have been working for a long time in the field of immigration, they can definitely, they have enough experience for sure to walk you through the forms and the instructions and fill it out correctly and send it correctly, and that might definitely be worth it. The only thing I would advise you is make sure to don't shift the responsibility of you knowing the process, understanding the process, understanding what you're filling out, where you're filing, how it works, and what's going to happen, just because you have someone who is doing it for you. Because most of the times, the problems with immigration cases, they start from exactly things like this. People think that just because they hire somebody, then they're gonna do everything for them, and unfortunately, that's not the case. All right, moving further to Date World. Date World says I-134-8. Date World, please provide more information, what exactly you want with the form, and I might be able to answer more. Moving further to Philip Thomas. Hi, sir, this is Philip again. This time my question is whether my son, U.S. citizen, is just completed 21 years of age and studying in University of California. Financial eligibility to apply for his parents and 15-year-old sister. Kindly consider my question. Thank you. God bless. Philip, thank you very much for another question. I really appreciate it. So, your son is now a U.S. citizen and now 21 years of age. Perfect. Whether my son's financial eligibility to apply for his parents and 15-year-old sister. Absolutely. I mean, honestly, what I would recommend, instead of instead of applying for sister, what I would recommend, I think it would be a better case, and I'll try to explain why. And I think it might be helpful for a lot of people. If your son right now petitions for the parents, that's going to be immediate relative category, which is great because you're not dealing with the backlog at all, and it's going to be processed, within year and a half, 2 years max. You're probably going to have your immigrant visa. You're going to come here. By that time, the little sister, she's already going to be 17 years old. At that time, as soon as you come into the country, you will be permanent resident. As soon as you enter, you file the I-130 petition for your daughter, the sister, your son's sister, your daughter. She's going to be 17 years old, and because you're a permanent resident, it's going to be F2A category. And F2A category roughly takes, we could take a look at the graph. Am I in graph A? Yes, I'm graph A. September 20, roughly 2.5, 3 years also. So by the time she reaches 21 years old, she will already have the immigrant visa. So much faster process. The whole total for you to immigrate and for her to immigrate, roughly you're looking at roughly 4 years. If, however, your son, and I'm pretty sure, let me take a look. Yes, if your son submits directly for his sister, for your daughter, it's going to be F4 category, which takes ridiculous amount of time. Right now it is roughly 16 years. So roughly 3.5, 4 years versus 16 years. Definitely don't want to, the choice is clear. Now regarding the financial eligibility, it really depends on the income, how much your son is, making. I do have a video on this channel that is specifically for the minimum income requirement in order to be a sponsor. But the worst case scenario, even if he's not making enough money to sponsor both you and your wife at the moment, then just, he will have to find a joint sponsor. And again, it's doable. But the sooner you start the process, the better. So the sooner he starts that process for you, because you're still going to be dealing with some time to wait. Alrighty, let's move on to our very last comment for today from Oracle. Hi, thanks for everything, help for us. I am filing I-864 and my 3 most recent taxes are all filled. Great. I didn't make nothing in 2020 because of the COVID. Yep, I can definitely relate to that. But filled because of receiving a rebate. Okay, in 2021 I didn't make nothing as well. What I made was really small because I'm self-employed. I made enough to meet the poverty guideline in 2022 even though I owe back taxes. My question is, can I fill out the 3 most recent with my last 3-year info and be okay? My next question is, what document do I need to submit with I-864W for my kids? Thanks, bro. Oracle, thank you for your question. Really appreciate it. So yes, you definitely should be good. It's really the most recent tax return that plays the most role. So for example, let's say you're submitting 3 tax returns, right? You're submitting 2022, 2021, and 2020. If you have made enough money in 2020, and then you made less in 2021, and then you've made less in 2022, that's not a very good picture. If you have made not enough in 2020, if you have not made enough in 2021, but you have made enough in 2022, that is a good picture because your most recent tax return shows that your income grew and now you're completely fine. Plus, like you said yourself, in situations where, the 2021, 2020 tax return looks horrible, we all have a good excuse. Closures during the pandemic, okay? These guys caused the closures and now that's the bad fruits of these closures. So that's a good explanation why a lot of people will not have a good income on their taxes. Now, as for the I-864W, let's take a look. We're gonna go to the forms, and I'm sure we can find the I-864W here. There we go. Request for exemption for intending immigrants affidavit of support. And checklist for required initial evidence. There we go. Let's see. Please do not submit this checklist with your it's an optional tool, so you use to prepare blah 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 blah. If you submit any documents, did you provide the following all Social Security Act forms necessary to establish that you have or can receive credit for 40 quarters? I don't think that's applicable to you, but let's take a look at the instructions. You have earned, so you must use Form I-864W instead of Form I-864 with your application for an immigrant visa or adjustment of status if any of the following apply. You have earned or can receive credits for 40 quarters with the SSA, Social Security Administration, and they give a few different options. The intending immigrant is a child who will become a U.S. citizen upon entry. All right, I think that might be your scenario. Let's see. So the child becomes a citizen under INA Section 320 if at least one parent of the child is a U.S. citizen. That means that you most likely will have to provide your U.S. citizenship, whether it's naturalization certificate or passport. Child is under 18 years of age. You will be providing birth certificate for the child, showing how old they are. The child is residing in the United States in the legal and physical custody of U.S. citizen parent after having been lawfully admitted to permanent residence. Again, pretty straightforward stuff. So it looks like you really don't need to provide much. Let's see, evidence. At the time of filing, you must submit all evidence and supporting documents listed in the what evidence must you submit section of these instructions. Well, let's actually copy this and we will see. Not the right combination of buttons. Control F. Boom. What evidence must you submit? What evidence must you submit? There you go. You must submit all the evidence requested in these instructions with your request. If you fail to submit requested evidence, USCIS. Wow, great. So there isn't really much that they say about the evidence here. Let's see. Let's take a look. Translation copies. You should submit eligible photocopies documents requested. Evidence. Yep, I would say there isn't really much required for the evidence. So if you are doing, this is I'm pretty sure this is the category that you will be applying based on. A child becomes a U.S. citizen under INA, so you're establishing your citizenship, you're establishing the relationship with the child, which is the birth certificate, and that's really it for the most part. So I would recommend going through these instructions once again. I'm gonna copy this in the comment and I'll post this in the link so that you know that I have addressed your question. There we go, and I'll put the link here. Let's see. There we go. Alrighty, so if you have any follow-up questions, anyone, do not hesitate to ask them. Just make sure don't respond to my comment within your comment. Make sure to submit a separate comment because responses, for some reason, YouTube does not send me notifications for those. As always, thank you very much for watching. Appreciate your time. God bless, and I'll see you all in the next video.